Advocacy. How to prepare for trial. There is no ideal way, and it often depends on the particular case, so you have to develop your own style, and your style will be derived from the people you work with, and your style will also be derived from the strong opponents. Now, the Supreme Court rules you learned in D.R.E. are important, so know them well. So here are the following few steps to prepare for trial. So step 1, know your cases really well. They'll dictate your statement of claim. So that's your case very well. Develop a clear strategy from the start, basically. So be strategic. Step 2, so really know your case very well. So take down detailed, relevant instructions and identify all material facts and how you approve that. So be cautious in your advice too. Step 3, work out what the issues are. So what relief do you seek? Who is your client? The cost. Also look at jurisdictions, so the power to grant the remedy you want, and also correct drafting of information and time limits. Step 4, pleadings, which must establish a cause of action or defense. Use plain English, so use precedents wisely, and when drafting defense, note rules regarding admissions. Step 5, write an advice on evidence, where you write the elements you need to prove on the left-hand side and the facts you need to support on the right-hand side. Then you'll see the gaps in your elements. Then pre-trial procedures you need to consider. So first of all, notice to admit. Once it's been admitted, there's no need to call evidence. Questions need to be set up so that you get a yes-no answer, and they're short, precise, and clear. Written answers. These are also known as interrogatories. They're rarely used, only in exceptional circumstances. Usually because the other side may not only answer, but they also may make inquiries and answer. And you've also got summary judgment, which is a statement of claim doesn't disclose the cause of action, as I discussed previously. Judgment on admission, which is that there is sufficient notice to admit, and that no need to trial on the basis of what's agreed and we've established a claim. And strikeout application, that's strike out a claim because the statement of claim or defense doesn't disclose a claim. Or filed offers, which is in the Supreme Court, if the plaintiff gets less than the defendant offers, then they have to pay for the cost, so it's worth considering. It is also possible to get an informal offer, which is highly recommended. Also, identify witnesses early. Since they may forget, get them to sign up and make a statement earlier. You've got the obligation to be courteous, so unlike some lawyers, don't send long, rude, snotty letters because it doesn't reflect well in the profession, and usually you can't get what you want to achieve because other people will become defensive. Now, opening address. First impressions matter. They can take an hour, a day, 10 days, the longest took 100 days. The opening statement should include a headline. So this is a summary in a couple of sentences about what the claim is. So for example, this is a claim made by the plaintiff for the damages for defamation arising out of an article written by the defendant dated the 3rd of August 2009. And also then comes the non-disputed or material facts. This is determined from the pleadings, so the correspondence between counsel, which should make the story. Then you got the disputed facts, the material facts. Then note that both of them should be material. You shouldn't put non-material facts in there, obviously. List of witnesses to be called, including expert witnesses. Witnesses you're going to call. Likely the plaintiff and the defendant are going to give the evidence first before any other people. So for example, Joe Jonas will give evidence about how he was telephoned by the TMZ journalist Brad Bennett about inside information he had about Mr. Shum on the night before the article was published. He will then tell Your Honor what he remembers the journalist saying. Then you've got the summary of the expert reports, and then you've got the law. So now, where the law is complex, it may be necessary to open extensively in the law, but there's no need to treat the judge as a bit loopy. Then the orders sought, so that is the remedies such as the damages or specific performance, etc. Now, the opening should be persuasive, which means that it should clearly recite material facts. It should have emotional impact, which means that it should discuss morality of issues and how it affects you or the judge. It should be formal and precise in language. So this means that you want to use a sincere tone. Now, you're also got to be aware of superlatives and absolutes, so you don't want to open too high and disappoint. So, for example, don't say Selena Gomez stated, "I'm madly in love with Jeremy Shum," when a witness may actually say that she could have actually stated, "I'm mad at Jeremy Shum." Make all your documents readable, which means only use one-sided piece of paper, use double margins, type or write using black, underline, so preferably using black to emphasize, use wide margins to align cross-references of points, and write main points on separate pieces of paper so that you can shuffle your notes easily. Usually a plaintiff who has a burden of establishing material facts is called first. Permission is required for a party to reopen, so you must put all your cards on the table and not required to reopen later on if you get kicked out. Only make claims to which you can call evidence, because if you don't and you call evidence that you can't prove, you'll look foolish. And pitch to the judge, so have a pretty coherent, unsentimental story, not to the jury. And also be precise, referring to the names of the witnesses, relevant documents and titles, and conclude by restating the verdict or order which you want the court to reach. The defense needs not to repeat the plaintiff, but to emphasize the differences between each party's case. The closing address. So the structure of the closing address is the introduction, the findings of fact, the law, and then the order sought from the court. So the introduction. Discuss what you will deal with in closing address. The finding of fact, which you believe should be found by judges. So which witnesses support the findings of fact you want, and why those witnesses should be believed, and which witnesses are against the findings of fact you want, and why it shouldn't be accepted. So for example, poor memory recollection, tendency to exaggerate or embellish, long-winded answers straying from the question, interest in self-serving answers, or unreliable. The law. So relevant legal principles to be applied. So for example, a state law will be invalidated by section 92 of the Constitution if it answers the description of being discriminatory burden on interstate trade and commerce of a protectionist kind. And that's Betfair and WA 2008. An order sought from the court. So for example, award of damages or declaration, injunction, or specific performance. Now, the art of persuasion. Advocacy is the art of persuasion, which involves getting the interest of the listener, making a desirable impression on the listener so you can form a relationship that's conducive to persuasion, and so be courteous and respectful to the judge and call him his or her honor at all times, and create a positive perception in the mind of the listener. Preparation is key to persuading, so be familiar and understand the facts of the case and know the relevant law or procedure. Now, in order to communicate clearly, you got to use simple and clear language. Vary the pace of your presentation, so sometimes you speak slowly, sometimes you speak extremely fast, and maintain an audible, appropriate demeanor, so don't go into the court looking a bit odd, and speak audibly and clearly, so loudly, but not too loudly. Avoid distracting mannerisms and habits. To keep eye contact with the judge or jury, so use notes but don't react to them. Use appropriate body language, structure carefully, be interesting, be simple, create images by interesting words, direct your story towards an objective, so conclusion, have an appropriate emotive content, and use simple but powerful language. Producing and tendering exhibit at trial. An exhibit is a document or thing produced in court as evidence, so exhibits are generally admitted into evidence via witness. Therefore, you need to determine which witness is appropriate to introduce a specific exhibit, usually the person who has the best knowledge and is able to authenticate it. The process of producing or tendering an exhibit is show the exhibit, so ideally a copy of it, to the counsel of the other side, allowing them to fully examine or object it. Put the exhibit before the witness, so it's usually the court orderly or tip staff who will do it. Ask the witness which lay foundation for the exhibit, so including, do you recognize it? How can you recognize it as required? Tender the exhibit before court, saying, Your Honor, I tendered the letter dated 25th of December 1950 as the next exhibit. Once you have established a proper foundation, its entry is not a matter of discretion, so you don't need to ask the judge's permission. How to object. If you believe your opponent has asked the witness an improper question, you can object. So to do this, you stand up and your opponent should sit down. You should state, Your Honor, I object to my learned friend's question. Now, stating object in Australia is not acceptable. State the basis for your objections. So common reasons for objecting are: question is leading, so this does not apply to cross-examination, and that's very important. So this is where it's directly or indirectly suggests a particular answer. The question is repetitive, so it's already asked or answered. The question is compounded, so raising two separate points. The question is argumentative, harassing, or offensive. The question is confusing, misleading, or ambiguous. The question calls witness to give an inadmissible hearsay evidence. The question calls witness to give opinion evidence, and witness is not qualified as an expert. And the question calls for witness to speculate. The question calls witness to select from alternative of several. The question calls the witness to make conclusion as to ultimate inference. The question calls witness to give evidence on material facts subject to privilege, such as legal advice. The question misstates or misquotes other evidence. The question is more prejudicial than probative. The question is relevant, not relating to material facts. And they should only object if you have suitable basis for it. Only interrupt if the witness's answer is detrimental to your case. If it's not, you just let them talk. Then the judge will then rule an objection, and you should then sit down. Now, make your objection before the witness responds, or if the witness attempts to answer, interrupt them. In criminal trials, juries have an aversion to objections. Counsel who continuously interrupt are unlikely to gain favour of the jury, who may perceive them to be disruptive and possibly even deceptive.